So I'm Josh Cohen, and I teach here at Stanford, among other places at the law school, and I'm chairing this final session, or final but for the closing comments by my colleague, Professor McConnell, that come after this. The topic of this session, as you know from the program, is, is sovereignty outmoded? Just hang up awaiting transcendence or not? That's my editorial edition. The format of the session, we have four distinguished speakers, and I want to make sure they have enough time. The format of the session is that they'll each speak for, my prediction is no fewer than 10 minutes. My rule is no longer than 15 minutes. My rule and expectation, that's my expectation and my rule. Why isn't my expectation? I only have soft power at my disposal, but anyway, I have more confidence in soft power maybe than others. Anyway, so they will speak for no longer than 15 minutes. Then we'll try to mix it up a little bit among the people who have spoken, and then we'll open things up to you all. I'm going to be brief in introducing the four speakers because you have a program in front of you, or anyway, if you want a program in front of you, you can have one. And I'm going to introduce them in the order in which they speak, which order is the order of the alphabet. First speaker is John Agnew, who teaches at UCLA. He is a political geographer who writes about issues of politics and place. I told John I was a little concerned about the fact that he writes, the three countries that he writes most about are Greece, Italy, and the United States. And I thought that bodes ill for our future. Anyway, watching, if you have an interest in financial markets, you know what I mean. The second speaker, Peter Berkowitz, is a political theorist affiliated with Hoover. He has written a book on virtue in modern liberalism and a wide range of opinion pieces, which I think stand for the proposition, I think this is a fair statement, that liberalism is both important and a lot harder than people think that it is. Doesn't come naturally. Yeah. Philip Bobbitt will speak third. He teaches at Columbia University and still some at the University of Texas. He has a distinguished career as a public servant and as a professor of law, and has both taught and written a great deal of great importance on issues that stand at the intersection of constitutional law and security. And fourth, sitting next to me, Kiron like Byron. Kiron and Skinner like Skinner. Yes. Yeah, okay. Kiron, thank you. I should have asked, and I apologize about that. Kiron is, like Peter, affiliated with the Hoover Institution. She also teaches at Carnegie Mellon and has also a distinguished career both as professor and kind of public intellectual, writing about issues of international relations and foreign policy. As I said, we'll listen, people will speak in the order of the alphabet, and the last time I looked, a last name alphabet. So John Agnew, you're first. Welcome and thank you.
Okay, thank you. I'm going to actually stand up because I have a PowerPoint and it's easier to see and to control from there. Okay, so it's very loud here. I've taken as my sort of basic question for this panel the idea of where is sovereignty. This, I mean, at first sight, this may seem like a ridiculous question. We've always seemed to have a sense that it's fixed somewhere or other, fixed territorially, fixed in given territorial spaces associated with the state. This is very much the sense that the world of political theory has had, and I think of law, at least in Europe, at least since the 17th century. So it's definitely an important but modern conception, really, of sovereignty. Because if we go back far enough, sovereignty didn't necessarily have that kind of association at all. And in fact, modern sovereignty has a variety of dimensions to it. When we talk of sovereignty, we often talk past one another because we are talking about very different things. We have this sort of idea of a Westphalian sovereignty, which is the notion of a world that's restricted to states, and there's in which order exists within the states, and there's disorder beyond, or anarchy beyond the borders of states. We have the idea of a domestic or internal sovereignty, which refers to, in a sense, the effectiveness of governments in terms of the authority that they exercise, and the recognition of the right to exercise that, of course. That's, in the end, what authority is, the legitimate exercise of power. But we also have these notions of a kind of international legal sovereignty, which has become particularly important in the 20th century, but of which there was a lot less before then. This is the kind of idea of the nominal equality in sovereignty between states. And sometimes people add, and the idea of a state exists because it's sort of recognized as such rather than because it has either of the other two elements of sovereignty. And then finally, a sense of states having a degree of not having to share any kind of authority with anyone else. Well, what I want to do is really challenge this sort of necessary association between territory and sovereignty. That's my sort of primary purpose today. It's become particularly common, I think, to do this because we think of globalization over the last 30 or 40 years at least as somehow undermining or coercing sovereignty, so that by and large we tend to think of a world in which there either was sovereignty and then there's a world in which sovereignty is eroding. So we have a kind of golden age of state sovereignty that we kind of look back to when everything was neatly territorialized, when we had a kind of Westphalian state system and so on. And now we have a world which no longer has that. So I want to argue that that's always been problematic, rather than just being a fruit of recent globalization, even though we can see that this is perhaps intensified in recent years. Sovereignty has never been neatly kind of bottled up or contained within territories, and I've used the phrase territorial trap to characterize this way of thinking. And what I want to do in my few minutes here today is to talk a little bit about this in terms of various sort of themes. The first thing is I want to draw attention really to two, I suppose that there are two major points that I want to make. The first one is that in fact sovereignty can be, even though it's associated and has been since the 17th century largely with states, it can in fact be shared, given up, licensed is the term I use to other agencies of one kind or another. And today we see a proliferation of these sorts of actors, private actors of all kinds, law firms and courts, international and supranational organizations, human rights organizations, charities, churches. Perhaps, you know, one of the most long-standing challenges to the idea of a singular state sovereignty was the fact that the Catholic Church did not disappear in the 17th century, but continued in many parts of the world to in fact have incredible authority over local populations. So that's my first point, that today we have all kinds of sources of authority, and some of these are long-standing, that in a sense, not so much undermine, but in a sense share sovereignty with states and the governments that we associate with those states. And the second major argument I want to make is that this is not necessarily territorial, that in fact it can be networked in all kinds of ways, that public and private actors exercising sovereignty do so often in very non-territorial ways. Increasingly, for example, immigration offices, customs, searches and so on are often carried out far away from the places associated with particular territorial sovereigns. Law enforcement, likewise, the operations of all manner of law enforcement agencies around the world, and not just those associated with the United States. Multinationals, banks, one of the best examples are credit rating agencies, essentially private organizations, licensed, if you like, in the United States, but having incredible powers. Maybe this is one of the things that joins together Italy, Greece, and the United States. They're all subject to the sovereignty of credit rating agencies like Standard & Poor's, Moody's, and Fitch's. So they're my first two, they're the most important points that I think I want to make. Just to give a couple of examples. My first example here is of Russian businesses. Fully 1/2 of all commercial litigation in London this year involved Russian businesses as both parties to the disputes. Why? Well, there are a variety of reasons for this. One, of course, is the law authority of Russia's own courts. You know, people don't want to engage in litigation in those courts. Many of the parties to these disputes have large external assets. You know, in fact, more of their assets are in Cyprus or Luxembourg or somewhere than they're actually in Russia. And then we have law firms in London that specialize in cross-jurisdictional disputes, that in fact are lawyers that operate at the interstices between the United States on the one hand, Britain on the other, and various other countries beyond that. A second example, and a quite famous one, the de facto sovereignty exercised by the United States at Guantanamo Bay versus the claim frequently heard that Cuba has sovereignty and hence so-called enemy combatants there have no status in petitioning in US federal courts. The so-called Boumediene habeas extraterritoriality test. So again, the notion that sovereignty can in fact be fragmented and dispersed geographically rather than just exercised over neat territorial jurisdictions. One way in which many people, political scientists, historians, sociologists, and geographers have approached this is to look at the world in terms of from two very different angles. The first is in terms of what we can call the failed state or quasi-state hypothesis. It's to say that, you know, in many parts of the world, states actually don't really exercise much in the way of any kind of domestic or internal sovereignty within their claimed territories, even though they may have, therefore, international legal sovereignty. That's about all it is. You know, they have a flag outside the UN and a soccer team and nothing much else. And in this case, this map is a map of some of the instability indicators from a foreign policy magazine issue of a few years ago, showing those parts of the world where plausibly one can argue the state really doesn't have much to offer to its populations in terms of the various things that we usually associate with state sovereignty. The rule of law, any kind of reliable or effective central bureaucracy, the list goes on. So this is one angle that we can use, and these are the top 20 states here listed in Foreign Policy Magazine's instability ranking. Out of the world's, 193 or 194 states here, 20 that arguably exercise very limited powers and have very limited authority within their space, and also in terms of things like controlling their borders or providing any kind of sustenance to their populations. The second direction in which people have tended to to examine the question is in terms of the world's creeping globalization since the 1970s and the various acts in the 1960s and 1970s that have enabled this to take place. Things like the US abrogation of the Bretton Woods Agreement of 1944 in 1971, which arguably is one of the things that's allowed the growth of world financial markets in the way that they've grown internationally over the last 30 or 40 years, and also the various rounds of the GATT, of the World Trade Organization, that lowered tariffs, particularly on manufactured goods, beginning in the mid-1960s. And so here again, we have a map of the globalized world. You'll notice that these are quite different maps. The other one, we're talking about the effectiveness of sovereignty within territorial boundaries. Here we're talking about the degree to which states have actually increasingly allowed other agencies, like the credit rating agencies I talked about before, to, in a sense, take over what maybe in the past could have been thought of as the powers that the states themselves had, but which are exercised with considerable authority. People tend to take the actions of these agencies very seriously. So large literature has begun to grow up in political science and in international relations in particular, talking about the role of private authority in world politics and the fact that, that increasingly our traditional talk about sovereignty has to be in some ways deflected to take into account these very important changes. So what I want to propose, just very briefly, is a different way of thinking about sovereignty, which asks where is sovereignty, and in a sense thinks of sovereignty in a relational way, thinking in terms of the world as a patchwork of more or less sovereign spaces and flows, reflecting this quasi-state phenomenon on the one hand and the impact of globalization on the other, and not a rigidly territorial order at all. That the world has never been as rigidly territorial as we've thought of it, and it's becoming decreasingly so, with some states and organizations, as we might say, more sovereign still than others. And what I come up with is a simple typology of what I call sovereignty regimes, which I've written about in a number of places, where we have a combination between, on the one hand, the degree to which there is some kind of effective central state authority that hasn't been licensed away, that hasn't, and that has a kind of effectiveness to it, on the one hand, and then the degree to which it relies upon upon territory as in a sense the geographical modus operandi on the other. And this typology generates really four different categories where we end up with a kind of classic case. This is the most Westphalian kind of case, where we have strong central authority on the one hand and a consolidated state territory on the other. We have a case of what I call a globalist case, where we have a relatively strong central state authority, but increasingly the state is opened up to the actions and the authority of various other, sometimes private, sometimes supranational, sometimes international organizations on the other. And then in the bottom, on the bottom row here, we have a weaker central authority on the one hand, but a high degree of state territory on the other, which would be associated with, for me, with confederative, integrative kinds of arrangements. The European Union would be a very good example of this. And then finally, my final category is an imperialist category, where we have essentially very weak state authority and nothing in the way of any restrictions on outside intervention, so that outsiders, in a sense, are truly sovereign, or at least potentially sovereign, in many of those places. So these are the four categories here, and I give some examples here, as you can see, of the classic classic one. China, fitting both the in contemporary China the stereotypical model, the imperialist one, various parts of the world where the United States or the Europeans essentially, or international organizations are more important. Integrative in the case of the European Union, then globalist, really this emerging world associated with globalization. So just to sum up quickly, we still tend to think of states in classic terms, this kind of territorial units of sovereignty that just kind of bump up against one another. I sort of claim here that this is not, that things are not as they seem. We tend to over-homogenize their geographical limits and miss the extent to which political authority is now shared across a range of private and public actors. And I've presented this typology as a way of acknowledging this complexity. So just to connect a little bit more with the theme of the conference, do territorialized constitutions then, like that of the United States, that fail to adequately recognize the actual complex geography of contemporary authority need revisiting in terms of pooling sovereignty and incorporating recognition of jurisdiction as no longer singularly territorial at all, but in fact functional in various ways. And I end here with a quote from a forthcoming article in the Stanford Law Review, perhaps the author's in the room. In a world where non-state actors transcend both territoriality and nationality, and where government operations have responded by becoming equally global in scope, territorial sovereignty and nationality/citizenship have become outmoded principles by which to define the outer limits of extraterritoriality jurisprudence. Okay, thank you.
Peter.
I want to say that I like Josh Cohen's remark that liberalism, the achievement of freedom in politics, is of course good, and achieving it can be more difficult than it looks. In fact, I think that's a good characterization what I'm about to say now. Although national sovereignty is not outmoded, versions of the theory of liberal internationalism sometimes suggest it is. This theory often purports to be the only reasonable interpretation of what freedom and equality require in the international sphere. In fact, liberal internationalism can be one-sided. To be sure, the theory of liberal internationalism has deep roots in the liberal tradition. But there's another view, also deeply rooted in the larger liberal tradition, for which national sovereignty is crucial to the securing of rights and the upholding of international law. You could call it conservative internationalism. But if you do, you should call liberal internationalism progressive internationalism and understand the roots of both in the larger liberal tradition. Now, of course, state sovereignty has always been contested, has multiple dimensions, the Westphalian, the domestic, international legal sovereignty. It's a matter of organized hypocrisy. The notion is twisted and stretched by law, diplomacy, politics, and war. But while the pure case may never have existed, law and public policy can bolster or erode a nation's sovereignty. Among American law professors, liberal internationalist interpretations of international law became in the 90s and continue to be today what American constitutional law was in the 70s and 80s, a leading vehicle for advancing social justice. The dominant view is that international law has a specific content and it corresponds generally to a progressive interpretation of government's obligations at home and abroad. This view is theory-driven. It holds that a good portion of the structure and content of international law, and I mean here in particular that part of international law that deals with human rights and the conduct of war, can be derived from reflection on our common humanity. Our common humanity, that is, as free and equal rational beings. Proponents of this approach generate dense lists of human rights, favor strengthening international institutions, multilateral initiatives, and NGOs, and see U.S. unilateralism as a major threat to international order. In the U.S., the liberal internationalist view draws support from the writings of John Rawls. In Europe, it gains intellectual heft from those of Jürgen Habermas. Both Rawls and Habermas theorize about principles under which free and equal rational individuals, liberated from partiality and prejudice, would choose to live, and from which they can derive binding laws and equitable public policy. International human rights lawyers may not invoke the abstractions of Rawls and Habermas. They may look to developing state practice, international institutions, and diplomacy as evidence of international law requirements. Still, for many scholars and jurists, it is moral and political intuitions, to which Rawls and Habermas give theoretical expression, that determines which examples of state practice, international institutions, and diplomacy they appeal to as evidence of international law requirements. And those intuitions determine which practices and institutions they ignore or suppress. Liberal internationalists sometimes see not this or that exercise of national sovereignty, but national sovereignty as such as an impediment to the protection of human rights and the creation of a just international order. For instance, Anne-Marie Slaughter, former head of the State Department's policy planning staff and dean of Princeton's Woodrow Wilson School, envisages, quote, a conceptual shift, close quote, by means of which we would view the world through, quote, the lenses of disaggregated rather than unitary states, closed quote. To take one of her principal examples, American judges should meet with increasing regularity with judicial colleagues around the globe. They should share professional experience, discuss common challenges, and seek shared solutions. This, quote, judicial globalization would produce an increasingly, quote, global constitutional jurisprudence. That, of course, is fine. But Slaughter wants this global jurisprudence to acquire the force of law. She envisages American judges bound not only by the Constitution and the laws and treaties made under it, but also by an emerging global jurisprudence of human rights law developed also by foreign national courts and supranational courts. She counsels abandoning the old idea, her language, of a unitary sovereign state whose internal affairs are its own business. Instead, we should view states, I quote, as aggregations of distinct institutions with separate roles and capacities. And we should encourage the emergence of, quote, a new international landscape, close quote, marked by an expanding array of crisscrossing and interlacing government networks. The goal of watering down national sovereignty is exposed to several objections. I'll mention 6. First, the status of international law can be murky. If, as John Locke argued, law must be settled, possess a common authority for adjudicating disputes, and have a recognized means of enforcement, then international law, again I mean here particularly human rights law and laws of war, often does not measure up. This creates theoretical puzzles and practical embarrassments. One could wonder, for example, how the rule of law was served by the consensus opposing the use of force to enforce law against Saddam Hussein. After all, over 12 years, Saddam flouted 17 Security Council resolutions, including a November 2002 resolution containing a final ultimatum demanding that he open his weapons programs to inspection. Not the failure to enforce make a mockery of the rule of law. Second, officials of international institutions charged with administering international law, as we've discussed already, lack democratic accountability. Those who come from democracies operate at several levels of remove from voters. Those who come from autocracies or dictatorships have never been authorized by free and fair elections. Third, liberal internationalism relies on the dubious idea that individuals do or will embrace global citizenship and that states do or will place their obligations under international law into global norms of justice ahead of their own national interest. But individuals seem inclined to put state, ethnic group, religious community, or tribal loyalties ahead of global citizenship, and nations still seem to prefer national interest. Fourth, liberal internationalism tends to underestimate the extent to which international law can serve strategic purposes. They argue that the increasing propensity of states to adopt the language of international law, particularly the language of human rights, shows the power of international human rights norms to shape state conduct. Perhaps, and to some extent, but a leader may attempt to deceive foreign audiences by insisting on his country's sincere respect for international norms. Indeed, in an increasingly interconnected world order, states must base relations with other states in the most universal language available. Today, that's the language of human rights, whether one's commitment to rights is sincere. Fifth, global or cosmopolitan duties conflict, or at least compete, with the imperatives of liberal democracy. Liberal internationalists maintain that states have a cosmopolitan duty to consider global welfare in the formation of national policy. That includes ratifying treaties and intervening to stop human rights abuses, even when such actions contradict their own citizens' preferences or entail painful sacrifices. In liberal democracies, however, citizens' sentiments and preferences differ, including those concerning the scope of cosmopolitan duties, security and prosperity are the organizing purposes of states, not universal benevolence, and solidarity and altruism, certainly descriptively and arguably morally, depend on familiarity and proximity. Sixth, from the point of view of the United States, further weakening of state sovereignty may become unlawful, could well be unwise. More narrowly, diluting sovereignty might violate Article 6, Clause 2 of the Constitution, which provides that the Constitution and the laws and treaties made under it shall be the supreme law of the land. More broadly, diluting sovereignty cuts against the theory of self-government on which the Constitution is based. That theory of constitutionalism, developed by, among others, Locke and in the Federalist, assumed a law of nations. This law of nations presupposed sovereign states whose rights and duties it sought to delineate. And it had good liberal and democratic reasons for this. All states, according to the international law presupposed by the Constitution, were formally equal. No state had the right to interfere with the internal policy of another, certainly not in regard to the gravest matter, determining when the most basic of rights, the right of self-defense, should be exercised. The law of nations embraced the principle of non-interference in the domestic affairs of other states on the grounds that states had greater interest in protecting their citizens' rights than other states or bodies. The traditional view does not deny universal principles binding on all states. Rather, it insists that the authoritative interpreters of those principles are nation-states themselves. Nation-states have the greatest capacity to protect and a unique interest in protecting their citizens' rights. A very important qualification often missed here. Not all nation-states, of course, rule in their citizens' interests. So it should be noted that the traditional conception of sovereignty is quite compatible with undertakings to protect individuals subject to genocide or other terrible crimes. After all, such individuals have been thrown by their rulers back into a state of nature. Their rulers have dissolved the sovereignty grounded in their capacity to protect those under their authority. In conclusion, let me make some of these concerns concrete. In September 2009, the notorious UN Human Rights Council published the Goldstone Report. The Goldstone Report gave UN backing to the accusation that Israel committed war crimes and crimes against humanity in the Gaza operation of December 2008-2009. The ostensible purpose of the Goldstone Report was to investigate facts concerning that operation. The Goldstone Report's fact-finding, however, was unreliable. Its legal findings were based on a misapplication of the relevant legal tests. Most importantly, and generally neglected, the Goldstone Report lacked foundations in international law. It infringed Israel's rights and responsibilities as a sovereign nation. How? International law assigns primary responsibility to investigate war crimes accusations to the judicial and other relevant organs of states. But the Goldstone Report rushed to judgment, never giving Israel a chance to complete, barely to undertake investigations. The assignment of principal responsibility for investigating war crimes allegations to nation-states themselves is rooted in traditional understandings of the claims of sovereignty. It assumes that nation-states, particularly those devoted to securing individual rights and based on the consent of the governed, or liberal democracies, are the best and most legitimate means of securing peace, preserving political freedom, and exercising authority over the individual. That's because such states, which must bear the burden of any rule or reform, are likely to be more sober in assessing the actions of other states than international organizations. One reason to prefer international law's current allocation of responsibilities to the allocation that the Goldstone Report sought to bring about is the Goldstone Report's stunning defects. Further shifting of power to international institutions for the administration of the international laws of war is likely to lead to further difficulties, particularly for liberal democracies in an age of transnational terrorism. International should not be confused with impartial and objective. Indeed, international institutions face profound obstacles to achieving impartiality and objectivity. These difficulties include the emergence of a transnational elite with its own interests and ambitions, this elite's lack of democratic accountability and national security responsibility, the General Assembly's domination by authoritarian states, and the frequent absence of agreed-upon authority for adjudicating and enforcing international law. Increasingly greater dilution of national sovereignty may be suited to a world in which all nation-states incline to peace and which all nation-states govern themselves in accordance with liberal and democratic principles. Unfortunately, that's not the world in which we live, nor is it a world we can expect to see emerge anytime soon.
I'd like to build on both John Agnew's presentation about the pluralism of sovereignty and Peter Berkowitz's views regarding the abdication of sovereignty by certain states. If other actors than states, especially those in the market, are exercising political authority, it is not only that the nation-state as a constitutional order is changing, is weakening, I think it's also that a new form of the constitutional order has come into being. So the answer, is sovereignty outmoded for states, is no, because sovereignty is a modality by which a state's constitutional order is defined. Different constitutional orders have different views of sovereignty. At the beginning of the 21st century, we still live in 20th century industrial nation states. And their legitimating mission to build a better material well-being for our nation still defines the contemporary constitutional order. Yet this mission is becoming harder and harder to fulfill, and publics know this. Few contemporary national groups, except those such as the Palestinians, Kurds, Tamils, or Basque, who are without states, seek their fulfillment in a relationship between their nations and a nation-state. It is increasingly difficult for the nation-state to execute the functions that it added to its portfolio when it superseded the 19th century imperial state nations. Not simply the maintenance of an industrial war machine of immense cost that is able to assure the physical security of its citizens, but also the preservation of civil order by means of bargaining among constituencies, the administration of juridical norms that embody a single national moral tradition, the control of the economy of the society in order to provide a continuous improvement in the material conditions of life for all classes, a control that has passed to markets, and an ever-widening scope of material benefits through government entitlements. It can hardly be surprising that nation-states face historically low levels of citizen and even civil servant satisfaction. Similar dissatisfaction can be observed with the 20th century corporation, a creation of the regulating 20th century industrial nation-state. Market regulation, and especially the regulation of private life, including personal matters like sex and reproduction by the state, has become increasingly unpopular. Many citizens feel they have been effectively marginalized in the political life of their societies, and political parties, unions, and elected officials themselves seem ever more marginal to the government of society. Private businesses and markets determine whether the economic policies of a state merit the confidence and credit without which no state can develop. At the same time, there are new security demands in the state that require ever greater authority, secrecy, and revenue. The constitutional shape that will emerge from this latest transformation could be configured in several different ways, as was the nation-state. But these varying forms will eventually achieve a consensus as to the basis of their shared legitimacy, and that basis will define the constitutional order. I've called this order an order of market states. A very gifted British diplomat, Robert Cooper, calls them postmodern states, and there are other names. They take their legitimacy not from the view that they will improve the material well-being of the nation, but rather that they will maximize their opportunities. As one commentator has observed, and I quote, The nation-state was defined and legitimated by its ability to ensure the material well-being of its citizens. In contrast, the market state earned its legitimacy by providing the opportunity to citizens to advance their own well-being. The nation-state is characterized by top-down, government-centric solutions that make absolute guarantees about the material outcome of its charges. The market state guarantees instead a set of basic tools and an open playing field, end quote. When you go from conscription and a draft to an all-volunteer force, when you move from unemployment compensation to labor retraining, when you go from defined benefits, pension plans, to defined contributions, when you go from state-owned enterprises like transportation or communications to sovereign wealth funds, in all of these movements, you're seeing the beginning of the transition to a market state. At some point in this century, a new constitution for the Society of States will come into being that reflects this emerging constitutional order by varying the degree of sovereignty retained by the people, an idea that is itself incompatible with the conventional conception of sovereignty as equal, indivisible, and complete. States will develop different forms of the market state, resulting in a pluralism that the constitution of this society will necessarily reflect. This new international law will be built out of devolutionary ideas of sovereignty, including markets in sovereignty, such as the European Union. If the nation-state came in three forms, a parliamentary, a communist, or a fascist nation-state, so too will the market state offer several variations. I will suggest three. One possibility is an entrepreneurial market state. Applying this model, deregulation and privatization are key figures of government. I should add that last year, more persons were hired as private contractors and outsourced by the U.S. government than were hired as direct employees. This goes hand in hand with other policies, including reduced rates of taxation, lower welfare benefits, coupled with greater job and labor retraining, freer trade, and relaxed immigration rules. Security issues are a paramount concern, and life in such a society might be best characterized as a permanent condition of impermanence when it comes to questions of government policy. It's a good environment for states of terror because it sacrifices legal rules, preferring to rely instead on markets supplemented by ad hoc legal action. Another possible model is the mercantile market state, which is more concerned with supporting commerce and preserving national and cultural identity. Here, strong alliances are forged between government and industry. Capital rather than labor is the focus of domestic fiscal policy. Protectionism has an important role. In matters of culture, ethnic homogeneity and continuity are core values. These policies are likely to lead to less international cooperation between states on matters of security, and alarmingly, less cooperation to prevent the proliferation of nuclear and other forms of weaponry. Here, too, market states of terror can flourish, in this case behind a facade of nationalism, or its twin, which is a regionalism. The third model might be called a managerial market state. Life in these societies is a high-maintenance affair. The economies are slower to grow and innovate, and efficiency is sacrificed in favor of social cohesion. Aggravating this will be the continuing resistance to the liberalization of labor markets in order to protect high-wage jobs. Managerial market states are more concerned with the quality of life than with growth, as in the entrepreneurial model, or with market share, as in the mercantile model. I'm inclined to believe that different approaches to statehood, more than the mishandling of our affairs, are responsible for the current differences manifest in our alliances. It is by no means impossible that these different constitutional forms might someday find themselves in conflict, perhaps provoked by the internal collapse of some other state, perhaps by disagreements regarding interventions in weak states, or perhaps when regionalism presents the same sort of destructive threat to the state system in the 21st century that nationalism did in the 20th, with all its propensity to conflict and the proliferation of weapons of mass destruction. The fault lines that might break into such conflicts lie along different conceptions of sovereignty. Roughly speaking, there are today three current views of state sovereignty that contend within the Society of States: opaque sovereignty, a classical concept that holds that events within a state's borders are entirely internal matters beyond the purview of other states. Translucent sovereignty, an outgrowth of European integration and the campaign for human rights, which holds that authoritative agencies like the UN Security Council can declare a state in violation of fundamental international norms against genocide, for example, and forfeit or compromise the perpetrator's sovereignty. And a more recent result of the human rights movement, transparent sovereignty, which holds that because a regime's sovereignty arises from its compact with its people as well as with the society of states, sovereignty can be penetrated when a state commits widespread acts of violence against its own people, or acquires weapons of mass destruction in violation of its international agreements, or supports global terrorists who threaten the civilians of other states. At present, important states holding some version of these paradigmatic positions are, for example, China and Israel, opaque sovereignty, France, Germany, and Britain, translucent sovereignty, and the United States, transparent sovereignty. The opaque sovereignty of the nation-state that is enshrined in the institutions and rules of the Society of Nation-States does not admit of any internal domestic acts that empower the United Nations or any other body to strip a state of its sovereignty, thereby making it legally vulnerable to legitimate intervention. Neither genocide, nor ethnic cleansing, nor human experimentation, nor slavery, nor religious persecution, nor even the calculated starvation of one's own population necessarily renders the state in a system of opaque sovereignty liable to intervention by other states. This is to be contrasted with the view, and I quote, that the word sovereignty can no longer be used to shield the suppression of popular sovereignty from external rebuke and remedy, end quote. For example, when the results of free elections are ignored by a local caudillo, who either takes power himself or assigns it to a subordinate he controls, a jurist rooted in the late 20th century could hardly say that an invasion by outside forces to remove the caudillo and install the elected government is a violation of national sovereignty. This emphasis on the popular sources of sovereignty is the basis of a transparent perspective. A translucent view, by contrast, stresses the common duties that states have towards each other and towards the society of states of which they are a part. For this reason, this perspective confines intervention to those endorsed by a collective international body. I'm sorry that Bobbitt comes so early in the alphabet and comes before Skinner, because I profited a great deal by Berkowitz and Agnew, who would have set higher to the homeroom roster than I. My fundamental arguments are these. One, that we're facing a fundamental change in the constitutional order, and that the very notion of a Westphalian system is deeply misleading. Two, that it may be that such a change will yield something like a market state, a state whose legitimacy differs from that of the 20th century industrial nation states. And three, that different ideas of sovereignty are correlated with different kinds, different models of the emerging market state. Thank you.
I would like to thank Professor McConnell for inviting me. It was good to get away from Pittsburgh and come back to sunny California. And I want to talk about two things. First, I will begin by just answering very briefly, sampling on the dependent variable, the question of whether sovereignty is obsolete. And then I'd like to turn and talk about the U.S. sovereignty, which I think is being challenged by U.S. domestic politics. So I think it's a great contrast to what we've talked about so far. In terms of whether the U.S., whether sovereignty is obsolete in the world, I think the answer is unequivocally no, however we define it. And I think there are some glaring examples, and we can debate these in Q&A. But I think the fact that there has been a proliferation in an unprecedented way of what I'd call the minis, the informal international regimes, is an indication that sovereignty is actually going strong. When I talk about the minis, I mean the proliferation from the G7 to the G8 to the G20. There's a call for G32. BRIC has now become BRICS. There's something called the G5 plus Egypt. I don't know why they don't go ahead and call it the G6. But all of these have websites. None of them are formal international institutions. None of them they don't have secretariats. They meet. They're a body of multilateral activities that are in some ways a response to the fact that the international organizations, like the United Nations, as one example, haven't been able to do what some of the member states want to happen, which is a pooling of sovereignty, a reduction of sovereignty. So I look at the proliferation of these, and there are just dozens and dozens of them with overlapping mandates and overlapping memberships as an example of the fact that sovereignty is in fact strong. Also, I think the fact that we, again, have a lot of multilateral activity, it's an analytical mistake when you read the charters of all of these informal regimes. They say that the world is multipolar, but multilateralism is not the same as multipolarity. And you see that basic analytical mistake in almost all of these informal regimes that have emerged. The fact that the United States is half the world's defense spending, that it's only surpassed by the European Union in GDP defined in terms of purchasing power parity, still I think about twice that of China, the next country behind it, suggests that the world is, if it's whatever polarity you want to talk about, you have to talk about, we're still in something like a unipolar world coming out of the Cold War. And within that, a very strong nation-state system with the U.S. as the predominant actor in that system. So to say that sovereignty still exists doesn't mean that international organizations aren't important. And what I want to talk about in terms of U.S. politics will go to the heart, I think, of why there's a lot of confusion in this country and debate to put on the one side Anne-Marie Slaughter, as Peter referred to, and then John Bolton on a very different side, why that's actually taking place. I think it's a proxy for something else. It is a discussion about sovereignty in international organizations, but it's also part of a broader proxy discussion about American domestic politics. So I want to start by saying that I stand with Theodore Lowy in the belief that the American creed is defined as liberty, individualism, egalitarianism, equality of opportunity, equality of man before God, natural rights, and limited government. I also stand with Martin Lipset in the belief that the United States is an exceptional nation because it so much believes and it's founded on the American creed. Not that it's called the American creed, but it's really a set of universal ideas that many countries embrace. The United States is exceptional. As he said, it's the first new nation founded on those ideas, not on institutional structures. And then I also stand with Samuel Huntington, who's argued that the American creed is the prime fault line in U.S. domestic politics, and how the tension between individualism and liberty on the one side versus equality and maybe egalitarianism on the other side are played out in American politics fundamentally affects the survival of the nation. I don't stand with Huntington on all the other things that he has said about, for example, the challenge of Hispanics and Catholics to maintaining the American creed. But I do agree in how he has identified the key fault line in the country. I think that fault line, how the fact that it's a tension, it's a fault line, has been healthy throughout the nation, the history of the country. But steadily since the middle 20th century, it's moved from a tension to a stalemate. And I think that's what we're seeing expressed quite a bit now in U.S. politics. And that stalemate has encouraged, in my reading of U.S. history, both sides, those political liberals who tend toward egalitarianism and equality, as the key kind of isms in American politics, and those political conservatives who emphasize individualism and liberty. It has led, the stalemate has made it difficult to get the kind of consensus on U.S. domestic politics, and has encouraged, I think, political actors and political theorists on both sides to try to in-run the country through the international system and try to resolve some of those debates going around the state. And I think that's a lot of what we're seeing in the sovereignty debate now. It's not just sovereignty qua sovereignty at the international level. It's how do we do some things at the domestic level that we want to achieve by going around the state. And so let me talk about how I think that came about and run through some U.S. political history, of which most of you who happen to be over 35 in the room are familiar with. I'm a professor, so I'm very sensitive to the fact how young people can be, and things that I think they should know, they just don't know, because I actually watched it on television as a child. But let me go back for a moment. I think the 1960s is a fundamental period in which this fault line turns to a stalemate, largely because more people became politically enfranchised into the system in the country. And so that might have happened in any case, but Lowy was writing well before that actually occurred. And for example, in 1964, we have Barry Goldwater running as a very different type of Republican for the presidential race on behalf of the Republican Party. Not the party of Everett Dirksen, not the party of Nelson Rockefeller, not the party of George Romney, some of his key contenders and opponents during that period. We come out of '64 with one of the largest landslides in U.S. history for the Democrat Party, with Barry Goldwater only winning electorally Arizona and 5 Deep South states. That began the process of a major realignment in American politics. But part of what defeated Goldwater so decisively was his inelegant way of opposing the Civil Rights Act of 1964. It wasn't that he opposed civil rights or integration and had in fact supported it with the Tuskegee Airmen and the National Guard in Arizona and the integration of other public institutions, but he began to make the kinds of states' rights arguments that we hear right now, his defense of the 10th Amendment and so forth. By 1968, we had Nixon winning, using a Southern strategy that further began to realign the solid Democrat South, turning it toward the Republican Party, those Southern conservative Democrats, largely white voters, to the Republican Party. And then in '72, Nixon took more than 70% of the Southern vote. The realignment was becoming firm in U.S. politics. All along the way, code words around race and the 10th Amendment and state rights were being used. And then as the civil rights legislation was passed and attempts to implement it through busing and so forth, and implementing the Brown decision, we got a split that was, I think, unnatural, not in the DNA of any party or the DNA of any people, in which the more conservatives in the country became those who were advocates of individualism and liberty, and those who were politically liberal, or maybe liberal and centrist in some ways, were advocates of egalitarianism and equality. It divided the U.S. electorate, I think, in unhealthy ways that made everything more difficult. But when we began to talk about international relations, anything that looked to be a kind of pooling or sovereignty, even where it's sometimes necessary, for example, on weapons of mass destruction, it's a little difficult to believe that the Proliferation Security Initiative ought to be done away with. It makes life a lot easier to have 90 other partners on the high seas volunteering to interdict dangerous cargo. But part of that debate happened as we hardened ourselves domestically. I think we hardened ourselves internationally, and it hardened our conceptions about sovereignty. on the more conservative side, everything that was about pooling sovereignty, even in an informal way like the PSI, became something dangerous and ought not be done. On the more liberal side, not being able to really fundamentally get at the civil rights that many had fought for in the 1960s and that began to be unraveled in some way by the Bakke decision, the Supreme Court decision of 1977, they began to think, well, we can use NGOs and we can use international judges, we can use various means at the international level, from formal to informal organizations, to get human rights on the international agenda and to make the United States more responsive to it. My sense is that the sovereignty is not fundamentally at the international level being undermined, but the sovereignty of the United States as a nation state is highly problematic in an environment when a natural tension becomes an intractable stalemate. And when it's being driven by an inability of a nation to resolve itself on the American creed, which is very, very difficult, which I think speaks to Professor Cohen's description of Professor Berkowitz's research around the difficulty of liberalism, because I think that's what I'm really trying to talk about from the standpoint of U.S. domestic politics. So it's a different way. There's a lot more I could say. I have a lot prepared here, but I find that prepared statements tend to constrain one, and I rather pull out the key points of what I want to say. And I think I've done that without giving too much history, but without giving too little as well. Thank you.
My belief in soft power remains unchallenged. We've stayed within the time limits. I'm very grateful to everyone for that. So just if summary of what people have said, but if I understood this, the question is sovereignty obsolete? John Agnew's answer is more or less yes, more or less. I mean,
it's always been obsolete.
Yeah, and it's even more obsolete than it used to be. Right, it's always been always been obsolete, but now it's whatever. Now it's decayed or something. I don't know. Whatever is past obsolete. Peter thinks both that I think descriptively it's not and normatively it better not be, something like that. Bobbitt, I think, thinks that in a way, the question as stated is a kind of a bad question, is sovereignty obsolete? Because the kind of sovereignty that we're familiar with is obsolete, but there are these kinds of sovereignty associated with the potentially emerging, arguably emerging market state, different forms of that, and that's not obsolete. That lies for better or worse in our future, something like that. Kiron, I think, first responded sort of straight to the question and said, no, it's not obsolete, but then also suggested that the question, the debate about the question, is sovereignty obsolete, is really a kind of disguised discussion of, in the United States anyways, a disguised discussion of a set of domestic arguments that go back to the mid-1960s. Is that a fair?
That's good.
Good, thank you, thank you. I aim for perfect, but I'll accept good. You know, we have about 20 minutes, and my initial thought was to have you all talk to each other a little bit, but I think maybe what I'll do is try to make that happen in the course of responding to questions from the floor. So, does anybody, I will, you, please. Microphone, thank you.
Colin Glassy, I'm a law student at Santa Clara. I would argue that the fact that Apple does not make a single component of the iPhone within the United States and could not make the iPhone without probably several years of retooling factories in the United States in order to construct this is a very strong argument against the concept that the United States actually has national sovereignty, at least at an important technological level. We are dependent on factories that exist beyond national borders for modern, high-tech components.
There are 2 points there, as I understood it. One is that we are dependent on factories beyond our goods that are essential to communication. Second is that that represents a challenge to ideas about does anyone want either to respond to the first or the second of those? Philip.
I don't know that sovereignty is the right term for the phenomenon you describe. I know what you mean, freedom of action. It may well be that we have greatly increased not only our wealth, but the spaciousness of life and the availability of these technologies for more and more of our citizens through this interdependent world, and at the same time made ourselves much more vulnerable to external shocks. But whether that compromises our, it may compromise our power or our independence of action, but whether it compromises our sovereignty, I'm not convinced of. Maybe I'm just being legalistic. I tend that way.
Say that like it's a bad thing. Go ahead, John.
Yeah, I had a couple of responses. You know, one thing is, of course, the United States has always been this vast economy that's never traded that much compared to many other major industrial countries. It's really only been over the last 30 or 40 years that trade has been as big a component of the total gross domestic product of the U.S. as it has been for much longer for many other countries. Think of Germany, you know, by comparison. And so I think that, you know, part of the reason why the talk of globalization in the United States is always so kind of hysterical is I think because it seems so new, when, you know, lots of other people have been living with the international division of labor for a long time, consuming things made in, you know, often a long way away from, you know, where they actually live. So that would be one point I would make. The other thing, though, is that what's interesting about many of these products, like the one you were pointing to, is that increasingly the kind of standards that relate to, you know, how they operate, how they work, and so on, are also kind of if not international, global in a sense. There are all kinds of international organizations, many of which we know, you know, very little about, that actually set the product standards and so on for these kinds of things. You know, that have annual meetings, and, you know, all of the, you know, techie executives from around here, you know, go to these things and so on. And from that point of view, these are rule-setting, standard-setting organizations that are, in fact, affecting the nature of products in different countries and so on, completely independently of the usual national channels that determine things like copyright and so on. And this is becoming now a major area of litigation, you know, in places like London and New York. You know, when, you know, how, you know, where do you go sue someone? You know, if you're trying to develop a new product that in a sense violates perhaps some of the rules set by these essentially private organizations.
Domain naming.
Yeah, exactly. Would be an example.
Can't solve the internet security problem. Anyway, go ahead.
I don't know if this directly answers your question, but I do think we sometimes confuse the concepts of sovereignty and international trade and free trade. But when you look at some of the founding documents for the United States, think about the Declaration of Independence, Washington's Farewell Address, and then to bring it more current into the 20th century, the Atlantic Charter. What these documents have in common is that they on the one hand, establish some terms for a nation, a new nation, and its sovereignty. And on the other hand, especially when we look at the last two that I mentioned, they also call for free trade and deeply involving the United States in national economic interdependence, and that those things aren't necessarily contradictory. That's been, and I mention those because they sweep over a period of history and in the United States, and they really have authority in how we've thought about our role in the world.
What about trade dependence?
Yeah, but those, especially when you look at the Atlantic Charter, I think it goes even deeper into understanding and what economic interdependence would ultimately entail.
Yes, John McGinnis, Northwestern, and I guess this is to Peter Berkowitz and Philip Bobbitt. I mean, could one add, maybe as number 7 of your defense of sovereignty in the modern world, an argument really by analogy to federalism? We might call it the international federalism argument for sovereignty. We're really quite ignorant of what often the effects of policies are going to be. We there in a world of competitive sovereigns, and without international norms, we allow substantial space for different policies, and then we can evaluate them. We can evaluate them in some sense with social science. We also can evaluate them to some degree by watching whether people leave the country or not. And I think this might be connected to Philip Bobbitt's very useful typology. There are a lot of different market states. We evaluate better how each is going to work, and indeed even within the different typologies of whether their policies are actually even going to achieve what they set out to achieve. And that's much easier in a world where we give substantial space rather than try to converge people to some set of internationally structured cosmopolitan policy. So I guess what I would say is one other problem with international cosmopolitanism, it does not recognize sufficiently the lack of information we have and the need to have structures that generate better information.
If it hadn't been for Josh Cohen's deft exercise of soft power, I would have had a 7th point, and international federalism would have been it.
I think it's an excellent point. So Louis Brandeis comes to the question of international relations. But I still am not prepared to say to you or nor to this young man that we're talking about the same kind of thing when we talk about sovereignty. It seems to me that you're talking about the power to achieve your goals. I'm not saying that's not important, but sovereignty is really a legal concept about the control of your will, not the success of your projects. Like international law terms of integrity, personality, these are terms that originate in the body and person of the prince, of his will. He moves his arm, he moves his hand. The body is responsive to his will. And that's true whether the body is very frail or rather powerful or very shrewd or rather dim. It just seems to me a different category.
Hi, I'm Shemin Keitner. So thanks for discussing all these issues so late in the day on a Friday. And I hesitated to even stand up because Peter, it's sort of, I'm not sure if you were here earlier, but a lot of what you said probably could have featured on a slide that Ona showed us at the beginning of her presentation. So maybe it's just that we're coming at these from fundamentally different perspectives. But I wondered, so a question to Peter and then a quick question to Kiron. In the sort of last few minutes of your remarks, what I think I understood you to be saying, so I'm just sort of asking for clarification, is that the Goldstone report was sort of intrinsically dubious because of its provenance in an international collaboration or from an international organization as opposed to a nation state itself. And I was just wondering, I mean, so would we have greater reliance on, I mean, would you be more comfortable with an investigative report produced by Turkey, as long as that's produced by, a nation state? Or what is it about the international provenance of the report itself that would lead us to conclude one way or the other whether or not we were confident in its conclusions? And then to Kiron, also, when you're sort of focusing on the individual liberty versus egalitarian or equality, and I think those are two very different concepts, but whatever, that's sort of, if you want to paint it as that divide, also wondering about the international dimension and the, whether you've looked at or interested in or have any thoughts about sort of the fundamentally close connection, both in terms of goals and ideology, but also actually practically in terms of people involved in strategies between the US civil rights movement and the international human rights movement, coming out of World War II. And again, that sort of the way in which international organizations can actually enhance individual liberty, and there's sort of a synergy between the domestic and international levels such that one can perhaps not construct such diametrically opposed categories.
First, I'm sorry I covered those important issues so quickly. My objection is not to international investigations. The biggest objection actually was to timing. Multiple sources of international law suggest that the responsibility for investigating accusations of war crimes falls first and foremost to the nation states involved. If they show themselves to be unwilling or unable, right? Article 146 of the Geneva Conventions, UN Charter, Rome Statute, of similar language. If nation states show themselves unwilling or unable, then international institutions might step in. The Goldstone mission was already authorized by the Human Rights Council before the guns fell silent in Gaza in January. That strikes me as in the sharpest conflict with these norms, and it seems to me that there are good reasons for placing that responsibility first and foremost. So, in the event that Israel had proved itself unable or unwilling, I would have not had an objection to international organizations taking action.
I wasn't quite clear on your question. Could you just state it a little bit more precisely?
So I think the suggestion was that positive or constructive relationship between rights movement, and that collaboration was not born of post-Baki failure of the American civil rights movement, and then a newly inspired idea about looking for international allies.
No,
Is that a fair statement?
No, it isn't, because I don't think that's what you were saying. Could you just say it again a bit more clearly for me?
Well, again, I understand you said that you sort of abbreviated your presentation in the interests of time. I think Josh's is one representation, but I'm just wondering what's the role in your vision of, you sort of said this liberty, equality debate is somehow hampering national sovereignty. I'm wondering where international instruments that actually enhance liberty figures in that vision.
I'm not exactly sure that I have the answers, because I'd probably get a prize if I did, but what I think I can slow down and say a little bit more to the kind of what I think is a false binary opposite that's emerged in U.S. politics, and how that's in turn affected our specific discussion about sovereignty through international institutions. So I think that's what the background of what you're trying to ask me to do. And so what, in my reading of U.S. history, there was a consensus moment, not just about the Cold War in the 50s and 60s, but one of political liberals and political conservatives on issues of race and rights, that produced some of the world's most historic legislation and court decrees. And that, by the late 1960s, began to break down around, as the movement broadened, and this is what I didn't say in the talk, to address other kinds of rights, and as the civil rights movement, became more radical. And the moderate white voter, especially from the North, who had supported these measures like the '64 Civil Rights Act, Voting Rights Act, wanted the Brown decision enforced, also became deeply concerned about law and order in the country. And that was one of the themes that brought Richard Nixon into office and helped George Wallace have the kind of popular vote success that he did as a third-party candidate. Something fundamental changed in the U.S. after that, and we see it in the 1970s. Those important white voters who had supported the kind of consensus that I'm talking about, that bridge, say, conservatives and liberals, we began to see an erosion of that, which emerged, I think, in what we see now with the Tea Party against almost everyone else as a fundamental stalemate on what this country ought to be doing on race and rights. And when you think about it, from 1968 to 2008, the Republicans controlled the White House for all but 12 years. You would think there would be a strong and durable conservative movement, a strong and durable Republican Party with its principles around issues like sovereignty very well laid out. That's actually not the case. We had on the more liberal side a kind of exile for all of those decades, and an exile kind of intellectual movement developing in the universities and think tanks that began to, I believe, figure out a different way to get at the same issues. And we get the focus on NGOs, the focus on international organizations, on human rights, more focus on human rights than I think intensely at the international level, and how that affects both domestically than we've seen at any point in our history. And for the first time in our nation's history, a president who's a product of that exile movement, so to speak, we can call it something else, it's not normative the way I'm describing it. And I think it has a big effect on our ability to work well within international organizations and not be irrational about what they can and cannot do and how dangerous some are, when in fact I say I'm sampling on the dependent variable, but the Proliferation Security Initiative, it's a little hard to see how anyone could be against that kind of activity. So I hope that gives a little bit more to your question. If you're asking me for answers, how do I fix this? I don't know. I just think it's part of the mix on the issue of sovereignty in the United States.
Well, this is just a brief follow-up. I hadn't intended to ask a question, but Shemen's question prompted me. I couldn't help it. Just to suggest that there's actually, I think, a kind of more interesting story in the period of the 1940s and 1950s than you may be giving credit to. Because during the 40s and 50s, you do see an effort to use human rights agreements to challenge Jim Crow, and a development of a strategy to actually use human rights agreements in the civil rights fight. And in fact, you see a really strong pushback against that, and you could read the Bricker Amendment controversy as motivated very much by a desire to resist the use of particularly the Genocide Convention to challenge Jim Crow laws in the South. And you in fact see the head of the ABA going around the country arguing against our joining these human rights agreements that, of course, Eleanor Roosevelt was key in generating, arguing that, making kind of outrageous statements that if a white man drives through Harlem and runs over a black child, he could be taken to The Hague and tried. I mean, it literally says this kind of crazy statement, which doesn't have anything to do with the agreements themselves, but is illustrative of the kind of fears around race that the human rights movement generated, and then the pushback that led to the Bricker Amendment controversy. And that Bricker Amendment was only defeated by a single vote, and only after Eisenhower promises basically never to sign a self-executing human rights agreement. And that's what now we call today the ghost of Senator Bricker. And now whenever we sign a human rights agreement, it always includes a non-self-execution clause. So you may not have been meaning to suggest that that wasn't the case, but I think that there's a really interesting connection in the immediate post-war era, at the very moment that we have the inception of the modern human rights agenda, that we see this early, very close connection between the civil rights movement and human rights, and that in fact it's exactly that motivates some of the pushback against human rights. It's precisely because people are afraid that it's going to change things domestically and lead to challenging of segregation and other race-related issues here in the United States. And that's the beginning of this dialogue about impositions on sovereignty by human rights agreements. So there's just a very interesting story to be told here. I tell a very small slice of it in one of my pieces. There's a great book that touches on this issue as well that it may be worth, for anybody interested in this, may be worth looking at.
Yeah, I agree with you about going back to the 40s and 50s, but you can keep going back, and I think after the Booker Amendment, we didn't see that kind of debate with that level of ferocity, but we, again, until a different form much later. So I agree with your basic point about the connection between trying to address or use issues of international human rights to redress grievances in the United States. But I think it was heated and divided in different ways, and it was a period in which there was still an overarching consensus, bipartisan, about the purpose of U.S. power in the world. That we don't see in this later period, which I think is another layer to which makes the stalemate so much more pronounced. But we could talk about that offline.
So maybe. Partly, but then it's become even more so. Anyway, on that cheerful note, I want to thank all the participants.